Uh-oh. Good evening, folks. Welcome to Monday Night Law on Kirk's Law Corner. Well, seems that I've been targeted. Both PayPal and my Cash App have been uh, shut down. So, whoever made that happen, I hope you're happy. It's not going to stop me from trying to educate people on the law, what our rights are, where they come from, how to effectively defend ourselves. So, I want to thank all my supporters out there that have donated through that way before. Um, I don't really know of any other way to accept digital donations at this particular point other than through Patreon, patreon.com/Kirk's Law Corner. That's pretty much it. Till I figure something else out digital wise, the only way to help support here is through the office at 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. So I want to thank everybody who has helped and helped supported the channels here, helping pay the bills, keep the bills going, and greatly appreciate you. So apparently, YouTube didn't like something that I had previously stated on the 19th about the thing, the thing that's going on. Apparently, they did not. They gave me a warning on YouTube, and I rebutted it, asked for an appeal, demanded proof, lawful. What was the lawful authority of these people to do whatever, blah blah blah. And apparently, they didn't like that response, and prompting them to provide the law. And hmm, I can go buy a prepaid loadable card at Walmart or a gas station and just ask for donations to be paid through Facebook Pay. Yeah, what about people on PayPal or pardon me, YouTube? But anyways, shit, lost my train of thought there. Yeah, anyway, they didn't particularly like it, I guess, and so they probably decided to target me a little more because, oh well, this guy's knowledgeable on the law and he's demanding us to provide the lawful authority of all this. Well, we'll just look into him a little bit deeper and we'll just shut him down. Um, so again, it's not going to stop me, right? I mean, at this particular point, I'm going to be looking at possibly getting on BitChute and Rumble. Now, just in case, right? It's always going to be go to kirkslawcorner.com. If anything goes down on Facebook, YouTube, whatever. For those of you that are not on Facebook anymore and are just barely hanging on to YouTube, you'll want to go to kirkslawcorner.com for any kind of an update, which again is now running off my own server right down here. So the only way they could technically shut me down there is um, cut my internet off or what have you. Um, right? God forbid I educate others. Being weaponized with the truth scares them, and that's what it is. They don't want us talking, right? That's why they want us wearing these things and staying 6 feet apart. Um, I don't know if that's going to trigger it right there. Can't even talk about that. And it's weird because I went in and looked at the terms and conditions over there on the PayPal thing, and it's like, where am I in violation of any of the terms and conditions? Nowhere. I can't find anything in there that I'm in violation of. So, um, for those who would like to, support, you can send over to the office, which is the standard address over there. At this particular point, I guess regular money orders or postal money orders, cashier's checks, or cash wrapped in aluminum foil, gold, silver coinage, any books or anything like that, that'd be awesome. We'll see, right? In my mind, I think there's some serious stuff coming, and it won't be like this for long. In due time, everything's got its course that it has to run out, and that's what we're waiting for, right? So, in due time, and I can tell you from my side of things what I've been working on, what my team and I have been working on. It's coming to a head, and I don't know if it's maybe some retaliation from that, or if it's from the YouTube, or what, but um, am I growing a beard? Well, there's some hair there, that's for sure. Um, Things are going to change for the better. Obviously, it can't. I mean, I suppose it could get worse, right? But I don't think the people worldwide have no real clue what's coming. Some say it's biblical. I'll agree with that. But let's get to some of the finer details, like global reset, money. There's all sorts of weird things going on out there with digital currency. And there's that other thing that's still in limbo that we're not supposed to talk about either. My understanding is that there are several now legislatures that have started uh, their own investigation, and I don't know, making some efforts to look things over with a fine tooth comb and see if the results are different. And when they find out that the results are different, there's going to be some big trouble. But again, everything has to go in steps, right? Due process of law here. Yep, 6 or 7 of them now. And being the key uh, swing states, should we say? right? All the fires, earthquakes, volcanoes. There's lots of stuff going on globally that's biblical, but I try to remind people that you don't think that these guys have read the Bible, that they couldn't be triggering some of these things to create these, you know, biblical outcomes. It's these people are so sick and evil that they could just make things happen, right? It's not it's not like we're not aware of how they control the weather. In fact, here in Idaho last night, we had one heck of uh, a windstorm blow through here around midnight through 3, 4 o'clock in the morning, and yeah, it shook my house a little. We had gusts up to clear up to like 70, I think it was like 75 miles an hour. So that's we get those every once in a while, so that's nothing really new. But there's definitely some stuff going on around the world that's falls in line with the Bible. So back to what we're working on. We're working on telling on these people, which is what I'm hoping the rest of you are at least trying to do. Um, you know, if your rights have been violated by public servants, you have the right to tell on them. And I know that Chris and I dug into the whole petitioning with the redress of grievances and all that, and that does work, right? And I know a couple of other people that have done it and used it, and it did some things for them. But what I'm really talking about is removing them from duty, getting them fired, and getting some sort of justice within a short period of time. Now, it's an interesting thing here, and sorry I haven't responded back to you, but I got a text message with a couple pictures of some paperwork. The one out of California, they filed the criminal complaint down there, and all of a sudden, the whole entire division of that court that they were in, every last judge recused themselves. And then a they pulled a judge out of retirement and put him in and it moved everything to a separate division. So there's you know, one little thing going on there, and it's kind of almost something similar that happened in Ector County, Texas, except for it took them about 6 months to shut down the entire family court in Ector County, Texas. 8 months, between 6 and 8 months. So, you know, for people out there that are not aware of how that happened, how that got started, in the practitioner tradition report, there's the name of a man by the name of Nathan Altenhofen. He was one of the three, Christopher, Hallett, Nathan, and Crystal, that was in the practitioner's judicial report. And that's how eventually how Ector County, the magistrate division of family court of Ector County, Texas, was abolished. The whole magistrate division of family court was abolished. Over 1,250 cases was bulk transferred to the district court. And they were told to be ready to go, show up on, was it December, I think it was December 21st of 2008, 18 or 19, 18, 2018. And they didn't show up ready to go, then their case was going to be dismissed. I'm pretty sure a lot of the cases got dismissed because the reasons why that particular division of Ector County, Texas, family court was abolished was because of all of the corruption and the fraud, the scheme, scam, the fraud, the lies. A lot of you are aware of that. Pretty sure most everybody here has had some sort of uh, exposure experience with people lying in court documents or in court about them. And again, the thing is here is how do we effectively defend ourselves with that, against that? The first part is you have to give rebuttal. You have to respond, because there's this thing called presumptions. There's presumptions and assumptions. And if well, I guess my audio is a little bit low over there, which is weird. I don't know why it changed, but let me crank that up over there for you guys. Sorry about that, Facebook. If the audio was a little low over there, that should be a little better. But anyways, we have to give rebuttal. There's a word called presumptions. So when somebody files some paperwork, you're supposed to look at your paperwork, right? And go over it with a fine-tooth comb, every single word on that document, and give rebuttal to everything that's on there. And then especially when you're talking about statements of facts, you'll want to do an itemized rebuttal to each one of those. And it's, well, they said this, and that's not true. In fact, this is the truth. And that's how we give rebuttal. So the presumption is if it's left unrebutted, it becomes truth, facts, and evidence in the record. And then the judge assumes that it's true because there's nothing in the court of record rebutting the presumptions. Now, another thing I come across a lot is people are like, well, they wouldn't allow me to put my evidence in. Da, 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 da. Well, again, in this particular situation, when we're talking about trying to present evidence, evidence is actually presented when you go to trial. Right before you go to trial is when you exchange evidence with the other side, not with the judge. That's not in the court of record. Your evidence doesn't go in the court of record, except for you exchange when you're ready to go to the trial or to the hearing, when you're talking about evidence type things. So for those of you that don't realize this, when you're saying that they won't allow you to put your evidence in, that's the reason why. Because it doesn't belong in the public record. And in fact, you're supposed to exchange evidence for the trial, and then there's a certain amount of time, 42 days for an appeal, blah, blah, blah. There's a certain amount of time, and then you're actually supposed to give that evidence back, supposedly. But there's a lot of things that we think are not right, when in fact it's us that's not in the right. It's because our lack of knowledge. And so the thing here is we don't go to a trial by jury or any kind of a trial on facts that are in the record, right? Statement of facts, clear, concise statements of facts, short, clear, concise statements of facts. Less is more. And when you're making statements of facts, it's actually the conduct, not, well, they violated my right to due process law. I get that. So tell me what they did that violated your right to due process of law. You have to articulate the actual conduct that violated your right to due process of law. The actual conduct of what the man or woman did. So This is the problem we have is we think that we can just say, well, they violated my rights. They violated my right. Well, that doesn't tell me what they did. Doesn't tell them what they did. So these are, little tips to uh, better effectively defend yourself. Everything has to be done in writing. Now there will be times where you'll get one of these judges out there that will allow you to speak, right? And they're a little bit nicer and a little bit more flexible. Then you have others that are pretty stringent and are just plain jerks. But I can tell you from my own personal experience, when I started giving rebuttal and doing my paperwork, things changed real quick. Now, one thing I've also learned, I want to put this out there, personal experience here, right? You always got to have that signed under penalty of perjury clause in your documents, or the clerk of the court will refuse your court documents. Again, that's my own personal experience, right? I did all this paperwork and took it in there to file it, and the clerk back there was looking over it, and it was about a good 5-7 minutes before they finally came back and was like, well, we can't accept these. I'm like, what? Why? They wouldn't tell me why. So it was a short time after that when I left to go to Minnesota, and I was working on Tim's case, and I started doing some paperwork for that and was sending it over to somebody else for oversight, right? And the first thing that she said was, well, where's your under penalty of perjury clause? I'm like, oh, ding, ding, ding. There it was. That's the reason why they wouldn't accept my paperwork. So our paperwork, for the most part, has to be in proper form, right? In the lower courts, they're not as particular, but it's a good practice to get your paperwork in proper form to begin with. Because if you ever go on an appeal for anything, your paperwork has to be spot on to go to the appellate court. No ifs, ands, or buts. Now, for those of you out there that are just like, yeah, I just can't, I don't know what I'm doing, I highly suggest that you find a paralegal, not a member of the bar, a paralegal. You can retain a paralegal to help you do your paperwork. They know how these documents are supposed to be in the proper form. And they're a heck of a lot cheaper than the member of the bar. And you can also read from your paperwork when you go into court. So that's somebody out there that can assist us, is these paralegals. And I'm telling you right now, you do paperwork, you're gonna get different results. I'm not going to say you're going to win, but I'll tell you right now, it sure raises your chances of getting what you want when you do the paperwork. And the other thing is the attitude that we have going in there. Don't always assume the judge is the bad guy. If anything that I learned from Fred Kelly Grant here, man that was in law for 60 years, was a judge's clerk, worked with our governor, and he wrote the book Justice My Ass. And one of the things that he was telling me in this story about this guy that got a public defender made the motion to dismiss, and the judge was going to grant it. Well, the parents decided that they didn't think that the public defender was good enough, and so they hired an outside attorney, outside member of the bar. And this new attorney comes in and says, "Well, we're gonna withdraw the motion to dismiss." And the literally the judge and Fred Kelly Grant had the conversation in chambers, of course. The judge was trying to save the motion. He was wanting to grant the motion to dismiss. Now, we don't hear these kinds of stories about good judges that are out there that want to do the right thing. But the key point here is the fact that the judge's hands are tied. They can only grant relief based on what we ask for. That's in the prayer for relief. But you have to make the proper statements. Your documents have to be proper. And so the when the judge came back the next time, well, it was, oh well, are you sure that you're okay? Asking the guy, are you okay? He was a young kid. He was like 20 years old, I guess. Of course, didn't know a whole lot of anything, right? At 20, who did? Especially in this realm of things. Are you okay with your new attorney withdrawing your motion to dismiss? He's like, well, yeah, I mean, this is, my parents paid for this attorney, and we think he's a good one. He's like, oh, your parents paid for him. Okay, so he went to the parents and said, hey, okay, your guys are the ones that paid for the attorney here. Are you guys okay with withdrawing the motion to dismiss? Oh yeah, we think we got a plea bargain worked out here, and blah 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 blah, and the judge is just cringing because he's doing everything he can to save the kid from the trouble of everything everybody goes through with this scheme, scam, and fraud of the bar and the corruption that's within the system. But here's one that really wants to try and grant relief on a beautifully written motion to dismiss and a brief and the whole 9 yards. But he couldn't. Uh, the problem was, I think that the new attorney that they hired, from my understanding, what Fred was saying was that the judge was saying that this guy is not very good at oral arguments. So that was the problem. So the key to this point that I'm trying to make here is that not all of them are bad. And the fact is if you do your paperwork and it's relatively in proper form and you have the right to demand that relief, if you can articulate it, the judges will grant it. I know I've had it done in a couple of my own personal cases. One was begrudgingly, I can tell you that, but I cornered her, forced her to read the rule of procedure. And once she read that rule of procedure, it was all over, because it was the scope and authority of the family court, which is they don't have subject matter jurisdiction over contempts, because contempt is criminal in nature. And even if it was civil in nature, okay, it still can't be heard in a family court, period. So for all of you out there that are in the family court realm of things and maybe getting hit with contempt of court, might look in your family law rules of procedure there, like for Idaho is Rule 101, the scope and authority of the family court to begin with. It says in there all this blah 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 blah, except contempt of court. And I know that the judge knew that was there. And she didn't want to read it at first. She was denying everything I was saying. I'm like, okay. And then, oh, well, on this other part here, well, no, the rules of procedure say this. Da, da, da. I'm like, oh, well, while you're there, why don't you just go ahead and read Rule 101? And she was like, I could just see it was like, gotcha. Because first you said you didn't want to go to the rules of procedure and read from the rules of procedure. But when it started you thought was going to benefit you, you went, pulled it up on your little computer and started reading from the rules of procedure. So again, another that reading means reading, and to know a thing and to be bound to know it are regarded in the law as equivalent. It's a maxim of law there, right? So again, for the most part, if your paperwork is proper, you've given the rebuttals, and you're demanding relief that can be granted, um, your chances of succeeding are a lot higher. Now, I know in a particular instance where somebody had done some paperwork based on the document templates that I've created, and somebody decided that they weren't right and decided to change them, and they filed them, and they did those documents didn't do anything. Nothing happened. They just ignored them. So they went back and redid the documents back into the way I had them and refiled. And again, this was 2 days after filing those documents. The judge called. This is a weird one, right? The judge calls the mother and said, "Hey, I've vacated your entire case. Go pick up your daughter." Wait a minute. That's because the paperwork was proper. It was done properly. And they recognized their own document template because on the motion to dismiss itself, I actually downloaded the document template from them. So it was their own document. How can you not recognize your own document template? But the key part is uh, properly articulating the grounds for dismissal. There are certain grounds for cause for dismissal, such as lack of personal jurisdiction, lack of subject matter jurisdiction, insufficiency of process, insufficiency of service of process, which was properly served. Insufficiency of process is due process of law. Hey, they violated my right to due process of law. Great, that's grounds for dismissal. Did you do a motion to dismiss and assert who did what, where, and when in a statements of facts in the motion to support the grounds for dismissal for insufficiency of process for violating your right to due process of law? Because if you didn't do that, the judge doesn't know. It's not in the court of record. So these are just the key parts to exposing the truth, right? You have to do the documents. There's no ifs, ands, or buts about it. If you want to succeed in any way, shape, or form, over and above where you're at now, you're going to have to do the documents. You're going to have to do them in proper form, make the proper arguments, supported by law, a brief. You're briefing them on your argument, and then there's a memorandum of law portion, and then of course points of authorities if you're going to use stare decisis to, a lot of times it'll be like, oh well, we'll let the courts sort that out. Well, no, the courts have already sorted that out, and here's the case where they discussed that this question was asked and answered. So now you tie their hands all up because you've already provided the evidence that question's already been asked and answered, and here's the law, right? The grounds for dismissal here. I'm claiming that they violated my right to due process of law. And you articulate that. And this applies to any case, criminal case, probate courts, family courts, it doesn't matter. It's on paper and anybody can read it. Any man of sound mind possessing logic and reason shall come to a reasonable conclusion based in reality, or they are insane. So start doing your documents, folks. Learn how to do these things. And part of how I learned was getting their documents from them and then going to the rules of procedure and going, well, wait a minute. This is how it's done. So I just essentially mimicked their own document and used it as a document template. So when you get your documents from them, I mean, there's your document template right there, folks. All you have to do is change the information in there and turn it around and give rebuttal to whatever it is that's on that document. If your name is misspelled, if they're making false statements, that's what you have to do. I know there's that maximum law out there that something about a heavy hardship. It's a heavy hardship to do the paperwork, to perform your administrative duties. I get it. I truly do. I'm not without suffering from that as well, but I've learned, I'm just like the rest of you. At one point in time, I didn't know any of this stuff. I didn't go to law school. Okay. I went to school of hard knocks. I, out of necessity, had to learn how to do this. And learning how to do it by example, I guess. Experience, that's where we get our experience from, is by going through the fires, right? And I've definitely gone through the fire a few times. Now, there's people out there say, oh, he's never won anything. Well, you clearly haven't looked at my record, because clearly I have. So you're making false statements about me out there. So, but that's it right there, is, they do lie, and they're hoping that they can get away with it. Now, remember, let's back up a little bit here. They wouldn't accept my paperwork because it wasn't signed. The under penalty of perjury clause was not in my documents. So if people lie and it's signed under penalty of perjury, you could file a criminal complaint for perjury. And if they have a member of the bar over there, that's subordination of perjury. So you can nail them both, because it's signed under penalty of perjury here. This goes right back to the negative nexus. You got the first liar, -1, times the second liar, the attorney presenting it to the judge, and the judge sees that as a +1. Because there's no paperwork from you giving rebuttal to the presumptions, and the judge automatically assumes what's in the court of record. It is what it is, folks. That's the way it is. Even the Bible talks about the pen is mightier than the sword, right? So I guess putting the pen to paper is mightier than the sword. And just like our tongues are sharper than a double-edged sword. So if you can put pen to paper, get it properly served and properly filed, and then go in and speak the law, make your arguments based on real law and the who did what, where, and when, you're going to win. And I can guarantee you're going to kick the crap out of them just by giving rebuttal. You start backpedaling like nobody's business when you figure out how to give rebuttal to the crap. And one of the key things is I demand strict proof in accordance with the strict standards of rules of evidence. So like on the civil side, you go through the document there, and you have to admit or deny the allegation. So if you're going to deny, which I highly recommend you deny everything, and then I demand strict proof in accordance with the strict standards of rules of evidence. Another one of those things that I found through paperwork, and was actually my own attorney's paperwork that I'm not quite sure actually got filed, because that was the paperwork where things started to change and turn around, and all of a sudden people were crapping their pants. And then, yeah, they had to do something to screw me over, which they did. And I'm not really going to discuss that right here yet because I'm going to take care of that and I'm going to take care of them. But once this is all done, said and done, I will come out and I'll show you my paperwork. I'll show you what I've done in my own personal case. But things got real weird there when I went in with uh, the attorney, the assistants, the paralegal there he had. And we sat down and we did the paperwork and I gave rebuttal point by point. And that's when things really started to weird out and change. And then when I went and picked up my case file later, when my attorney decided to dump me because I just a different contempt of court, which was the failing to go to the parenting class that the judge ordered me to go to, and it was her own contempt of court against me from the judge, and she had to dismiss that with my attorney sitting next to me, who says, "Well, I'm just going to let him speak." Yeah, that's right. So doing this paperwork and giving that rebuttal, and I found that in the rules procedure, and as well as on some paperwork that we did, there was that one little thing in there that said, "and demanding strict proof." Well, I went to the rules of procedure and I was reading through there and I found that, oh, if you want, under the rules of evidence, if you want to invoke or evoke the strict standard, which gets rid of hearsay, again, unless you invoke or evoke the strict standards of rules of evidence, they can say whatever they want and get away with it. But as soon as you say, well, I demand strict proof in accordance with the strict standard, the rules of evidence, now this gets interesting because they actually have to have firsthand knowledge evidence, got to have a witness to back it up, or some really solid evidence to present. This is a key to defeat them in their hearsay. Because again, that makes it so that hearsay is no longer admissible. In fact, I can pull that up and show that little tidbit, which I believe I've showed it before, but it has been quite some time. Now, I know this is Idaho, but keep in mind that rules of evidence, rules of procedure are pretty synonymous because ultimately they all come from the rules of the common law. If I can remember where it's at. Um, well, here's a good one. Judicial notice. This rule governs judicial notice of adjudicative fact only, not a legislative fact. Kinds of facts may be judicially noticed. The court may judicially notice a fact that is not subject to reasonable dispute because it is generally known within the trial court's territorial jurisdiction or can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. Now, again, this is the rule of procedure. Well, we have a conflict here because watch this under the code, Title 9, right? Yeah. Judicial knowledge. Now, this is also where you do judicial notice here. This is what goes over to the jury. You get to submit this as evidence to the jury. Facts judicially noticed. So here's a rule of procedure that's subverting the law. The true signification of all English words and phrases. Uh-oh. This is how we get rid of the bar word salad. Judicial notice. Driver, one who is employed for hire. Right here at a Black's Law Dictionary. That's the true signification of that word when it was created. Etymology here. And of legal expressions. Contract. Whatever is established by law. Public and private official acts of the legislative, executive, and judicial departments of the state of the United States. The seals, the accession of office. But let's get down right here. Wait. What's this? The laws of nature. That's right. Judicial notice of the laws of nature. And nature's God, that which endows us, right, with certain unalienable rights. Among these unalienable rights are what? Life, liberty, and the pursuit of happiness. Right there. Now, if I could just find the court must take judicial notice if a party requests it, and the court is supplied with the necessary information. Uh-oh. They must take judicial notice. Instructing the jury. In a civil case, the court must instruct the jury to accept the noticed fact as conclusive. In a criminal case, the court must instruct the jury that it may or may not accept the noticed fact as conclusive. Well, that's great. But the fact is you can instruct your jury. It's your jury. Just saying. And this is how you do it. Judicial notice. Let's see. So in a civil case, unless a statute, Idaho appellate decision, or these rules provide otherwise, the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. What was I just talking about? But this rule does not shift the burden of persuasion, which remains on the party who had it originally. That's right. The burden of producing evidence is satisfied by evidence sufficient to permit reasonable minds to conclude that the presumed fact does not exist. If the party against whom the presumption operates does not meet the burden of producing evidence, the presumed fact must be deemed proved. If that party meets the burden of producing evidence, the jury must not be instructed on the presumption, and the trier of fact may determine the existence or non-existence of the presumed fact without regard to the presumption. So if you don't rebut the presumptions, it goes right on through. That would be the effect of leaving something unrebutted. But if you do rebut it, the burden of proof is actually on the moving party who had it originally, which is where you demand, right? And see, here you go. When a presumption operates in a civil case, the court must instruct the jury that the fact has been proved without using the term presumption. Uh-oh. Because it's the truth, facts, and evidence in the record without being rebutted. Unless otherwise provided by statute, criminal case presumptions that operate against the defendant. Recognized at common law. Whoa. Right in our own Idaho rules of procedure on rules of evidence, talks about recognized at common law or created by statute, are governed by this rule. For purposes of this rule, statutory provisions that certain facts or prima facie evidence of other facts or of guilt are treated as presumptions. So you have to give rebuttal to them. Well, that's not the whole truth. Well, what part of it's not true? And this is where you get in when you start making your own statements of facts. If you got one thing in there that's just not quite true in that one particular itemized statement, that whole statement can get blown away. So be careful when you write your statements of facts. Submission to jury. The court may submit the question of guilt or of the existence of a presumed fact to the jury only if, on the evidence as a whole, a reasonable juror could find guilt or presumed fact beyond a reasonable doubt. Instructing the jury. When the existence of a presumed fact operates against the defendant, the court must not instruct the jury to find a presumed fact against the defendant, must not instruct the jury in terms of a presumption. Their hands are tied. The court must instruct the jurors that they may draw reasonable inferences from facts proved beyond a reasonable doubt and may convict the defendant in reliance upon an inference of fact if they find that such inference is valid, and if they find that the evidence as a whole, including the inference, convinces them beyond a reasonable doubt that the defendant is guilty. There's that beyond a reasonable doubt. It's funny, they got him in here pursuant to the rules of evidence. Let's see. Wish I could find that word. Talks about invoking the strict standard of rules of evidence. Yeah, they try to exempt him, and actually, I think that's part of what it was. Actually, is in like the family law. Let's go to family law real quick. Click it. That's where it was right here. Watch this. This is where it's at. Notice that here's one or A. Applicability of Idaho rules of civil procedure. Well, this is the family law rule, right? Oh, wait. Idaho rules of civil procedure apply only when incorporated by reference in these rules. Appeals from family law cases shall be governed by the Idaho rules of civil procedure. Applicability of Idaho rules of evidence. Here we go. Upon notice to the court filed by any party within 30 days after a response or other responsive pleading is filed, or if none, within 42 days from the filing of the motion or petition, or such other days may be established by the court, any party may require strict compliance with the Idaho rules of evidence, except as provided in Rule 102b3. That's down below here. If no such notice is filed, all relevant evidence is admissible, provided, however, that the court shall exclude evidence if its probative value is outweighed by the danger of unfair prejudice, confusion of issues, or by considerations of undue delay, waste of time, needless presentation, and cumulative evidence, lack of reliability, or failure to adequately and timely disclose same. This admissibility standard shall replace rules. Now, look at these. This admissibility standard shall replace these rules. Idaho rules of evidence, except as provided in Rule 102b3. All remaining provisions of the Idaho rules of evidence apply. So basically what it's saying here is if you require strict compliance with the rules of evidence, these don't apply. Regardless of whether a notice is filed under Rule 102B1, records of regularly conducted activity as defined in Rule 8036 Idaho Rules of Evidence may be admitted into evidence without testimony of a custodian or other qualified witness as to its authenticity if such document appears complete and accurate on its face, appears to be relevant and reliable, and a seasonably disclosed, and copies are provided at time of disclosure to all other parties. That's so that you can give rebuttal to it and say, no, 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 no. I'm going to demand strict proof in accordance with the strict standard of the rules of evidence. Hearsay is not admissible as evidence if you invoke the strict standard. We go back to that, and let's go in there. 801 through 806 is the main ones right there. Oh, hearsay. That's how you get rid of hearsay, folks, right there. That's okay. You know what I just showed you there. Rule 801 through 809. Oh, wait, where did 809 go? Weird, it jumps right into 901. Huh. But yeah, I mean, that's what we're dealing with here. Let's go back just. Oh, 801 through 806. I saw the 9 here. So 901 through 903 and 1002 to 1005. Huh. Authentication identification. Imagine that. Yep. So that's how you do that. According to the rules of evidence and rules of procedure, right here, upon notice to the court filed by any party within 30 days after response or other response of pleading is filed, or if none within 42 days from the filing of the motion or petition. And that's kind of what I did in mine. Was I said, well, I deny all of these and I'm going to demand strict proof. And then when I went in and did my rebuttal stuff, said that, hey, this is not true. And in fact, here's the truth. And I'm going to demand strict proof in accordance with the strict standard rules of evidence. That's how that got shut down. So back to the family law. Here's the rule 101, right? These rules govern the procedure in the magistrate division of the district court in the state of Idaho in all actions for divorce, legal separation, child support, child custody, and paternity. All proceedings pursuant to the Domestic Violence Criminal Protection Act, all actions pursuant to the De facto Custodian Act, and all proceedings, judgments, or decrees related to the establishment, modification, or enforcement of orders, such as except contempt. Right there. Bam! This is the scope and authority of the court, the family court, except contempt, which means they don't have subject matter jurisdiction. That is grounds for dismissal for lack of subject matter jurisdiction. So, motion to dismiss for any contempt hearing that they file in the family court. You can do a motion to dismiss the contempt charges in Idaho. You may want to read your own, but in Idaho, we can make a motion to dismiss right from the get-go for lack of subject matter jurisdiction because the family court doesn't have subject matter jurisdiction over contempt. Now, there's another one in here that I found that was pretty neat. I wonder if it's was saying in here if jurisdiction subject matter jurisdiction is challenged at any time, then they have to dismiss. I was like, what? Hey, look, here's your general appearance or special appearance. Huh? Hidden in the family law. It's also in the Idaho Rules of Civil Procedure too. Tells you how it's got to be done. Here's your default judgments. Setting aside a default judgment. Okay, so here's your motion practice, right? Defenses and objections. When and how presented by pleading or motion. Motion for judgment on pleadings when presented. Summary judgment, declaratory injunction, declaratory judgments, injunctions, form and scope of injunction, grounds for preliminary bond, evidence on motions. Where is it? Oh, but then they have contempt in here. Actions for contempt shall be governed by Rule 75 of Idaho Rules of Civil Procedure. Now, this is the one that she went to. And I said, okay, that's great. Civil. So we got to go into a civil court. This court, family law court, doesn't have jurisdiction over contempt. Well, you pulled this rule up. Now go read Rule 101, the scope and authority of this court, which she knew. So this is the contradicting rule. Actions for contempt shall be governed by Rule 75, the Idaho Rules of Civil Procedure. Oh, where in the heck was that at? I wonder if it's in here. Hey, look at that. Lack of jurisdiction over the subject matter, lack of jurisdiction over the person, improper venue, sufficiency of process. It's the same stuff, guys. Failure to state a claim for which relief can be granted, failure to join, another action pending. There it is. Whenever it appears by suggestion of the parties or otherwise that the court lacks jurisdiction of the subject matter, the court shall dismiss the action. So even if you make a suggestion that there's a lack of subject matter jurisdiction, the court shall dismiss the action. Why? Because this isn't lawful. Just saying. Now, see here's where they say, oh, well, a defensive lack of jurisdiction over the person, insufficiency of process or insufficiency of service of process is waived unless it is made by motion prior to filing a responsive pleading and prior to filing any other motion other than a motion for an extension of time to respond or otherwise appear or a motion under 107, 108. It is not waived, however, by being joined with one or more other motions or by filing a special appearance as provided in Rule 206. Now imagine that. This is where they say, well, laches occurs, and well, you can only challenge personal jurisdiction in the very beginning. And if you do that, you waive challenging. No, jurisdiction can be challenged at any time because what we're actually talking about here is fraud. You got the wrong person. If you've got the wrong person on the paperwork from the get-go, that's fraud, and fraud vitiates everything from its inception, void ab initio. But here it is. If we can learn this, right? So that when they do file something against us, you immediately file a notice of special appearance objecting to the personal jurisdiction, and you demand proof that that's the person on the paperwork, that you're the person that's on the paperwork, and then claim fraud or whatever, especially when the name is in all capital letters. I'm not that person. Sorry, that's a corporate fiction. You're trying to run a corporate Ponzi scheme here because suits have to be in like kind. This is supposed to be a suit between a man and a man. You can't have the state of Idaho versus a man because that's not suits in like kind now, is it? Yeah, it would have to be the state of Idaho versus Kirk's Law Corner LLC, or me as an Idaho notary public. That's right. Those would be persons. I would be the person as the owner or the notary. Those are different statuses in my proper person as a notary, in my proper person as the owner of Kirk's Law Corner LLC. Now, what business do you have with Kirk's Law Corner LLC or me as a notary? What contract, even if it's tacit agreement contract, do we have? Well, we don't have a contract. Oh, well, then there's no subject matter jurisdiction here because the subject would be the contract and the matter would be the terms and conditions of the contract, and personal jurisdiction would be the parties to the contract. So not only can they screw up on the paperwork and not have personal jurisdiction, but if there's no contract, there's no subject matter jurisdiction. But if there is a contract and, they're a party to the contract and they have a right to a cause of action pursuant to the terms and conditions of the contract, and they properly identify you, us, whatever, then there is personal jurisdiction. There is subject matter jurisdiction. But if there isn't, then there is not. There is no personal jurisdiction if they don't get it right. Got the wrong person here. And, what I go to with my notice of special appearance is that this is a corporate Ponzi scheme and it leads to human trafficking. Put that in there as a statement of fact and articulate that as a statement of fact that the use of the all capital letters name is a corporate Ponzi scheme because suits have to be in like kind, and you're attempting to attain parity between the intangible, the state of Idaho, a fiction, and the tangible, the man, by putting my name in all capital letters and trying to deceive me under fraud so that you can human traffic me because you're using the all capital letters name because that's what's on the birth certificate and my social security. Yep. Hint, hint, hint of what's going on out there. Not all human trafficking is sexual in nature. Part B of human trafficking is debt slave, peonage, involuntary servitude. You've been attained to pay this bill through bills of attainder, bills of pains and penalties. That's that color of law. Any legislation that describes a punishment that says this is a crime, well, we don't need a victim. Yes, you do. That's a bill of attainder if it's not. And then says, here's the punishment for that from the legislation. That's a bill of attainder, bills of pains and penalties. That's subjecting us to pretended acts of legislation. Because the legislative branch of our form of government here does not have the power to make bills of attainder. They don't have the power to say, this is a crime, and if you do this, this is the punishment. Nope. That power doesn't exist. And in fact, it's strictly prohibited. Article 1, Section 9 and 10 of the Constitution of the United States of America, as well as every state constitution. So, what is motion practice? Motion and other papers. An application to the court for an order shall be by motion. So you're applying to the court demanding relief in the form of an order, but it has to be in the form of a motion. Which, unless made during a hearing or trial, shall be made in writing, shall state with particularity the grounds, therefore, including the number of the rule of family law procedure or Idaho rule of civil procedure, if any, under which it is filed, and shall set forth the relief or order sought. A proposed form of order, if included, shall be a separate document. The requirement of writing is fulfilled if the motion is stated in a written notice of the hearing of the motion. Captions, signing and form of motions. The rules applicable to captions, signing, and other matters of form of pleadings apply to all motions and other papers provided for by these rules. The caption, the signing, the form, like you gotta have in there that you're signing this under penalty of perjury. Okay, that's a proper form. Now the caption is the upper portion of the document. Who is it in to? Is it in the in the fourth judicial blah 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 family court? Okay, who is it? Who is it? Who is this document addressed to? And then who are the parties? Every state has their own proper format of the caption portion of the document. So they all, they have to be in proper form. It's just the way it is. Of course, then there's time limits and all those other things. Now, if the moving party does not request oral argument upon the motion and does not file a brief within 14 days, the court may deny such motion without notice if the court deems the motion has no merit. Well, of course, the motion would have merit if you articulate in your statement of facts supporting the grounds. There's no really need for the brief, but I'm telling you right now, you got to do the brief. at least in some instances. Stupid little things, you don't need to necessarily. But if you're going to get into some of the heavier stuff, then you need to have a brief. I mean, if you can state with particularity within your motion, your substantiate your grounds with your statements of fact supporting those grounds, cool. We should be good because it's prima facie. It's on its face. So now you can also request oral argument. And actually, I'll go back up. It shall not be necessary to file a brief or memorandum of law in support of a motion, but the moving party must indicate upon the face of the motion whether the party desires to present oral argument or file a brief within 14 days with the court in support of the motion. So, when a motion is supported by affidavits, okay, here you go, people, right here. Supported by an affidavit. Now, affidavits specifically, they are in support of. They're part of the motion. They're in support of the motion. This is motion practice. This is how you get your statements of facts in there. You do your motion and you do your affidavit of truth, statement of facts of who did what, where, and when. Now they have 21 days to respond. And it's got to be done at least 14 days prior to the specified hearing. And you have to do a notice of the hearing thereon shall be filed with the court and served so that it is received by the parties no later than 14 days before the time specified for the hearing. Excuse me. But here's the other thing is, technically speaking, when you're doing this through the court of record, like motions for dismissal, challenging jurisdiction, the court doesn't have any say, and there's no need for a hearing because jurisdiction has to be proven in writing. And we also have the right to do our own default judgment. There's going to be some interesting stuff that once I get this completed for myself, I'll share it with you. But I know somebody that has done it, and somebody who might even be on here watching right now. So I've actually heard it from two different people. So, and it's kind of weird that the gentleman was telling me about what he's doing over there, and then that was a Wednesday night, and then Friday at the office, another gentleman come in and was talking about it and actually showed me his own little stamp thingy. So I'm like, holy crap, for real? So that was like, divine that they showed up with that, and I was like, whoa, okay, all right. So I'm on board with it. I'm getting there. We'll see what happens. But for the most part, if you want do any other kinds of motions, motion to strike, motion to quash, motion for this, motion for that, you have to call the clerk of the court and say, hey, I want a hearing for this motion. It's a motion hearing. Okay. They have to set it at least a certain amount of days out to afford you the opportunity to properly serve the other side and afford them the opportunity to respond. Because all those documents got to be done before you go to court. Because again, you can't talk about something on the record that's not in the court of record. So even in the instance of doing a motion to dismiss, okay, When they don't respond, well, that's a default judgment. Now, you call up the clerk of the court and you say, "Hey, um, I need a hearing for default judgment hearing." Okay. They give you a date that's usually about 30 days, maybe 40 days out. That gives you the time to send that over, give the 21 days, and then they're supposed to have 21 days to respond. And if they do respond, they're supposed to give you another 10 days to respond back. And then another 5 days for them. Or no, actually, it's just 21, 10. No, it's 21, 10, and 5. Yeah. So all that's supposed to happen before the hearing. And then whatever's in the court of record, your documents, can be talked about on the record. And so if you know this and you've done your due diligence, you've performed your administrative duties, and you've created your court of record, your documents, especially when you do a brief memorandum of law, this is where you get to bring the law. You get to lay down the law here. Well, this is my right. This is the right here. This is the law. I'm claiming this right. I'm standing on it. Well, the claim and exercise of right can't be converted into a crime, and there shall be no rulemaking that would abrogate the rights of the people. Miller versus U.S. and Miranda versus Arizona. There's two really good cases right there that just kick rocks, get off my property. But see, this is where you become the law sayer. You get to bring the law. You get to speak the law. And then so when you go to court, you get to speak it because it's in the court of record. Judicial notice even. Where was your sources? Well, that's in your brief. Your brief memorandum of law with points of authority. You get to cite your sources. Judicial notice, Your Honor, blah, 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 blah. Here's my right. I'm claiming it. Okay. This is when we start winning, folks. And there will be some judges out there that will enjoy the heck out of these hearings because it breaks up the monotony. And I've had judges just get ecstatic for having a hearing. I'm like, what? Ooh, I want to hear this one. Whoa, what? Yeah. They're not all bad. And even the bad ones may get a kick out of it sometimes. So when you learn this stuff, and it's not so much as learn it, it's just do it. The fact is, if you just put some stuff down on paper and properly serve it to the other side, it's going to do something. It's better than nothing. And then when you get into court and they start talking blah, 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 we say, well, objection, Trinzi versus Pagliaro, well, maybe enlightening, Trinzi versus Pagliaro. Well, while statements made by the attorney over here may be enlightening to the court, he has no firsthand knowledge. He can't testify from there. And somebody's going to have to take the stand and testify here. Period. Because that's not where we testify from. Not only that, attempting to enter facts on the record that are not in evidence. Oh. Dun, dun, dun. That's a key one right there. When they start saying hearsay and blah, 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 blah. Well, if you've given rebuttal, said that that's not true, and I demand strict proof in accordance with the strict standard of the rules of evidence, when in your responsive pleading, when they go to try and talk about it, well, objection, Your Honor. Attempting to enter facts on the record that are not in evidence. I gave rebuttal to that, and I demanded strict proof in accordance with the strict standard of rules of evidence. I'm going to demand some evidence to support that claim. You got any evidence, counselor? No, just hearsay. Okay. Sustained. The objection is sustained. You are to refrain from making those statements, and it is to be stricken from the record. Dope. That's how we shut them down, folks. And again, this kind of stuff doesn't matter the difference between criminal or civil or probate or anything. This is all the same concept, the same idea, the same rules, rule of law, just how it is. But if you want to start prevailing in your own case, that's just what you got to do. Yeah, it's the other thing is see when we do our paperwork, right? When we do our paperwork, we're creating a record, and that's why it's called the court of record. When you file a criminal complaint against somebody, say you've done your due diligence, you've created the record, and they railroaded you. Okay, that don't feel discouraged, don't feel defeated, because a lot of times, especially in the lower courts, these de facto kangaroo courts, they play the game of we're going to do whatever we want to do, and catch me if you can. Because these people have just gotten away with it for so long. They're so corrupt. They think that they're above the law, that they're not going to get caught. And they're praying to Satan that you don't have a lick of intelligence here to know how to tell on them and get them in trouble. They're preying on our ignorance here. But let me tell you, firsthand knowledge here. When you do this stuff, things change, and they change real quick. So when you go to tell on them and you file a criminal complaint against them, well, somebody has to get those records. This is why it's important that we do our paperwork and create the court of record. Because when somebody comes in to do an investigation, they're not going to talk to you. They want to see the court of record. What did you put on the record? Did you give them notice? Did you afford them the opportunity to do the right thing? And they didn't, because that's what you're complaining about. Okay. That evidence is sitting there in the record that you put them on notice. That here's the law. I'm objecting to this. I want this dismissed. I want this vacated. That's hearsay. Get that out of here. Blah, blah, blah. Your document says so. How can they give rebuttal to what's in the court of record? Ignorance of the law is no excuse. So, when you send somebody in there to grab this record and that there's prima facie evidence of your court of record that you followed due process of law, which is the first step, is notice an opportunity to do the right thing. And when they don't, they become culpable. I don't care who they are. I don't care in what proper person they're sitting in. A judge, a sheriff, a CPS worker, a police officer. I don't care what emolument they're sitting in. It's called ultra vires. You step outside of the scope and authority of that emolument you're sitting in, because we the people dictate the scope and authority of that emolument and the duties under that emolument, you lose all immunity. You can't be granted immunity for screwing up and stepping outside the law of creation of that emolument. No, sir. I don't care about your Ruckel-Feldman doctrine, because the judicial branch doesn't have the power to make law. We go to Latin, ultra vires. You're outside your scope and authority, you lose all immunity. But see, you really want to nail them, it's criminal, because really their immunity is from the civil side, right? In reviewing Hardwick versus Rican, again, Ninth Circuit Court of Appeals, took 17 and a half years to come back and say, well, no, you can't lie to separate a parent from their child. Come on. Give me a break. 17 and a half years to say that? So this is how we're going to affect change, folks, is really, really telling on them. That's what we need to do. And it's a criminal complaint in a federal district court. Now, again, it's, uscourts.gov, form A091. Let's do it that way. Okay, uscourts.gov, right here, service and forms. Then I go over here to criminal forms. There it is, A091, criminal complaint. Now, I'll kind of just give you an idea how this works. Notice that this says United States of America versus, because they're supposed to sue, prosecute on our behalf, public servants. So here's the code section and offense. This is a public offense. Now let me show you, because I know people have asked for this, and a lot of times I just assume people get it. So I guess I need to stop assuming. Whoops, what did I do? There we go. You want to go to Title 18, right? Crimes and criminal procedure. And we always go to the crimes here. We talk about 241, 242, right? That's a most common one out here that a lot of people are aware of. Deprivation of rights, conspiracy against rights, and deprivation of rights. Okay, I'm going to show you. Watch this. See how easy? So, I, the complainant, right, in this case, state that the following is true to the best of my knowledge and belief. On or about the dates of, you put the date, so this is the when, in the county of where, in the district of, the defendants violated United States Code 241. What's the offense description? Conspiracy against rights. This criminal complaint is based on these facts. See attached statement of facts. Click the checkbox, print that sucker out, take it down. You don't sign it, right? This is supposed to be signed, sworn to before me and signed in my presence. The way it's supposed to work is that we are supposed to lay this complaint before a magistrate. And in reality, it's, justice of the peace. But we're supposed to lay this before the judge, and we're supposed to be sworn in to tell the truth, the whole truth, and nothing but the truth. So help us God. Once we're sworn in, we can make these general statements or supported by an affidavit of truth. Oh, that's right. Affidavits. Okay. And if you've got any witnesses, now, here's the key thing you need to know is if you're going to do it this way, and you have witnesses and affidavits and paperwork and all that stuff, you keep the originals. Always keep your originals when it comes to evidence. Make copies. Turn it in with the complaint. And what we're seeing now is that they won't let us go in front of a magistrate to lay this before. They're not wanting to let us go that far yet, but in due time. Right now, they're actually taking them in the federal district courts, but they don't want us to know that that's actually, they play the game of, well, you can't see a judge, you can't see a judge, blah, 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 but we'll go ahead and take your complaint. That's right. And I'm telling you right now, the more of us that do this, the better off. And the sooner we get people on this, the better off we're going to be. Now, the only other way to do it at a state level through the Attorney General's office, which is what I've done. I've also done a few of those now. We're rocking those. I just do Attorney General for Idaho. Watch. Lawrence Wasden, there's our man. Consumer complaints, consumer protection, what have you. Where did it go? File consumer complaint. I would like to file a complaint. I want to file hit the drop down box. How about a public corruption complaint? Now, I've heard some people out there that say that that particular one is not there. But okay, I'll answer the question out here on YouTube. Is 241, 242 law for man or person? Both. But it's for public servants because that's a public offense. This is why code is not law. That's why there's a lack of personal jurisdiction against the man. Uh-oh. Did I just let that cat out of the bag? Okay. Objection to personal jurisdiction here. Notice a special appearance objecting to the personal jurisdiction. You're trying to charge me with a crime under bills of attainder, bills of pains and penalty for a public offense. I'm not a public servant. I don't have a stipend attached to some office. I'm not subsidized by taxpayer dollars, and there's no subject matter jurisdiction here because there's no contract to receive a subsidy. Anything in Title 18 is penal law. That is criminal, not civil. This is criminal. Title 18 is criminal. Do not file a Title 42 1983 civil rights violation lawsuit and go to Title 18 criminal. Wrong jurisdiction. If you're going to go civil rights violations, you have to articulate what the right was that was violated. What was the conduct that violated the right, and what are the damages? That's it. Because rights are the law, not Title 18. Now, you want to go after them criminally, you got to go to Title 18. That's a criminal complaint. So, right here, public corruption complaint is criminal. It's pretty much the same thing as this form right here. But notice it says criminal complaint. Well, where did I just take you? Right here. It is civil rights, right? Chapter 13. Under crimes. That's right. Now here's an interesting one. Should be number 4 here. Misprison of felony. Whoever having knowledge of the actual commission of a felony cognizable by the court of the United States conceals and or does not as soon as possible make known the same to some judge or other person in a civil or military authority under the United States shall be fined under this title imprisonment not more than 3 years or both. It's a felony. So if you make it known that these guys are committing felonies and they don't do anything about it, they become culpable. This is also a criminal complaint against them. It's filing a complaint is what it is. Okay. That's what needs to be done. This is what's been made available for us right now. It doesn't matter about any of the SMU. Okay. Focus. I'm showing you the documents. I'm showing you the law to use that they use for them to prosecute them. So, under the state level one here, all it's asking for is who did what, where, and when. They're not even asking you to cite any kind of a code. So, this is all up to you which way you want to do it, or if you do it at all. Okay, folks, I'm going to reiterate this. Federal District Court in the United States District Court for the, you've got to figure out what federal district you're in, put it in there. This is federal. These are military tribunals. This is what Trump has put back in place for us to use. Okay, and I'll show you right here. Article 3, Section 2, right? in law and equity arising under this Constitution. Da-da-da-da-da. What is that? Cases of admiralty and maritime jurisdiction. They're under admiralty jurisdiction. Think about this. President is the commander-in-chief. Chief. That's a military rank. Governor, commander-in-chief. That's a military rank. Chief of police. That's a military rank. Sergeant, military rank. That's admiralty jurisdiction. Article 6, Clause 3. Everyone from the legislative branch, executive branch, and judicial branch shall be bound by oath or affirmation to support this Constitution, both state and federal. They're under admiralty jurisdiction. Okay? Now, this is the kicker. Watch this. Article 1, Section 8, the scope of the legislature. What's that? To constitute tribunals inferior to the Supreme Court. Tribunals. What kind of tribunals are they? Military tribunals. They're supposed to be there for us to prosecute the public servants for public offenses. Oh, good Lord. All right, let's do this. Somebody out here saying, oh, we should read Title 4. What? Wait a minute. Title 4? That's the flag stuff. Who cares? Completely irrelevant. We're talking right now, we're talking Title 18. Crimes. Criminal procedure here. File a criminal complaint against public servants from the code, which is a public offense. Okay, and I'll just reiterate that here and show you what I'm talking about. Right there, public offense. Okay. So for a violation of private rights and private wrongs is supposed to be civil. What? Yeah. The common law is supposed to be all civil. So now let's read this a little bit closer. The distinction between actions at law, suits in equity, and the forms of all such actions suits are hereby prohibited, which they can't do, but anyways. And there shall be in this state but one form of action for the enforcement or protection of private rights or the redress of private wrongs, which shall be denominated civil action. Now, listen to the verb or verbiage, words, diction. And every action prosecuted by the people of the state as a party against a person. Whoa. Are we picking up what's being laid down here? Person. In their proper person. Charged with a public offense. For the punishment of the same shall be termed a criminal action. Public offense. Criminal complaint. On behalf of the people against a public servant. Right here. Public servant goes here. Where did it happen? When did it happen? What's the code? What's the public offense? Conspiring against rights. Do your statement of facts and you're done. That's right. Person is in the public. A man or the people are in the private. Hale versus Henkel. Okay. Ethics in government. Title 74, subsection 2.1. The people of the state of Idaho, in creating the instrument of government, do not yield the instrument of government that serves them, do not yield their sovereignty to the agency so created. Oh, give me a break. What I'm trying to teach right now and educate the people on has nothing to do with Title IV. Absolutely nothing. That's flag code. And everything's all messed up right now. And I'm telling you right now what's been put in place by Trump for us to tell on these bad actors and get them removed from duty. And you're going to see it here real soon. It's going to be epic. It's going to be huge. I've already been working on stuff. I've already had public servants arrested. Okay? You picking up when I'm laying down? Because I'm showing it to you right here how to do it. No, citizens are person, public. The people are private, having sovereignty. God is the sovereign. The Law of Nations, written by Amber de Vittel. It's in book 3. I think it's like chapter 20, section 212, I believe. Citizens are those that are bound, right? So citizens. So I mean, how can we be called people and the people retain their sovereignty and do not yield our sovereignty to the agency so created and be a citizen at the same time? You can't. You got to know what these words mean. Citizen is a public servant. They're bound by the Constitution, Article 6, Clause 3. That's who the citizens are. Okay? So we also have people that are called free inhabitants, vagabonds, paupers. Oh, we haven't heard those words used in a long time, huh? But what does it say in the Articles of Confederation? The free inhabitants. That's right. So the people essentially are those that have political power. However, you get political power, one way is by registering to vote. Yeah, I know about the corruption. I get it. But let's speak in lawful terms in our original form of government and the way it was set up. This is how you became one of the people, claiming your political power, your status. Now, originally, you had to be a landowner, and you were actually called an elector. So that gave you your political status and your proper person as one of the people of the territory of whatever. So, number 2, you can become an elector, elect elected to any position of emolument. And we required back then, way back then when all this started, to put up your land as surety. So when one of the people want to sue you for violating their rights, they could seize your land, civil asset forfeiture. And if you were so corrupt, yeah, we could seize your land and run you out of town. Exile. So this is how it was set up. Things kind of got a little messed up there around 1871, didn't they? Where Congress usurped their powers and said, "Oh, well, we're bankrupt here. Sign this. Give us your gold, your silver. Give us your land." This is exactly what's going on right now. This global reset that they're wanting is because it all came to an end and was foreclosed on and terminated in 2012. Okay. Technically speaking, we've gone back to 1776, like Trump said we've gone back to 1776. And I want to reiterate what Trump said in his inauguration speech. He was putting the power back into the people's hands. I'm not depending on Trump for anything other than what he's already done to reorganize our form of government back into a way that we can actually do something about it. Okay? He put the military tribunals back in place where they belong and put it there so that we can go tell on these public servants for those involved in serious human rights violations, human trafficking, and corruption. That's why it's a public corruption complaint. He created the Joint Task Force on Consumer Fraud. He dug up the executive order from 1984 on the Manual for Courts Martials, the Uniform Code of Military Justice, and made amendments to them. That's right. He put things back under a de jure form of government, at least what he could do. It's up to us to claim and exercise these powers. Nobody else can do it for us. It's going to have to be us, folks, because all political power is inherent in the people. We have the right to alter, reform, or abolish anything at any time we deem it necessary. Our rights and our powers do not depend on the president. In fact, even as the president, he's still a public servant. And we have the power and the authority to instruct our representatives to discharge the duties of that office. So, but we have to follow due process of law. And that process comes from the common law. You have to tell on them. Now, because they're public servants actively engaged in serious human rights violations, human trafficking, and corruption, Trump has made those amendments to the Uniform Code of Military Justice, Uniform Code of Military Justice, and the Manual for Courts Martial, which all came effective January 1st, 2019. Why do you think it's been such a shit show since January 1st of 2019? Because they know that Trump put things back in place. Those are all federal courts are now military tribunals like they're supposed to be in accordance with the Constitution. From 1787, the original Constitution of the United States of America, 1787. So, knowing this, knowing all of this because I followed it, not Q, I followed Trump. I followed his executive orders, his proclamations, what he said he was doing, the words that came out of his mouth. That's what I followed. Okay. And I put this stuff out as he was putting it out. For those of you been around long enough, can you affirm that? You remember when I was putting these executive orders and the proclamations and the memorandums, press briefings, and the stuff that Trump was putting out, starting clear back in 2017. And it really started kicking up in December of 2017. That's when Trump started dropping the hammer. Yep. I've laid this out as it was being laid out to us. I was trying to inform people, this is what, holy crap, this is actually going to happen. We're getting our republic back if we can keep it. Okay. But we're supposed to do this without the use of force and violence, fundamentally and principally. You know, our founders wrote in their documents that, we have petitioned, we have remonstrated, and only been met with repeated injuries. Because that's the First Amendment, the right to petition the government for the redress of grievances. Okay. That's the civilized way of doing things, of telling on people, right? I'm not saying we don't have the right to defend ourselves with arms. What I'm saying is that we're supposed to do things in a civilized manner first. Do everything we can in a civilized manner first. If it comes to actually defending ourselves with arms, so be it. But let's do everything we can in a civilized manner first. Let's be the better man. And just tell on them. There's the documents. I just showed them to you again. Now, I showed a little bit more how to fill it out, which I figured people would figure it out how to do it, but apparently not, which is okay, right? I don't know everything. I'm plenty ignorant of lots of things. So, crap, I didn't know half of this stuff. Well, yeah, I didn't know half of this stuff 4 years ago, right? Reading means reading. Got to study, got to learn this stuff, and I'm just trying to pass it on. So, other than that, I hope everybody had a good learning experience tonight. And let's take back our power. Let's start telling on these bad actors and start filing these criminal complaints. One way or the other, either through if your state has the public corruption complaint online right there, you can do it right there. Now remember, misprison of felony there, you've informed the Attorney General's office. But in my experience with the one that we did out there, it was weird because it turned out to go all over into the federal side of things. How did it go from the state Attorney General's office over to the federal side of things? You tell me. Let's think about that for a second. Who's actually on the other side, the receiving end of these public corruption complaints? It's go time, folks. Now I was talking about misprison of felony. Title 18, subsection 4. Chapter 1, subsection 4. We're making them known about these crimes. And it's under public corruption complaint. That's a criminal complaint for corruption, right? Yeah, thought so. So that's it. I mean, we can learn how to do petitions and petition the legislature for the redress of grievances and all that stuff. That's great. If you want to alter, reform, or abolish anything at any time, that's fine. Do that. But at this particular point, Things have been put in place for us to tell on them and start removing these bad actors from duty. Whether they go to prison or not, I don't know. Some may not, depending on the amount of corruption. But I can tell you right now, when you do file these, somebody's looking at them, somebody's executing things, things are being investigated, and things are happening. People are getting arrested, they are getting removed from duty. So if we could just get more people to do it, the better off we're going to be as a nation. Okay. Any questions? No, just kidding. Of course, everybody has lots of questions all the time, but hopefully I broke that down a little bit better tonight for people to pick that up and do that. And it doesn't, now again, you're going to do this, keep quiet. You don't talk about it. Like even right now, I don't give names. I don't say who did it. I don't say what happened. And from that particular point on, I really don't know anybody else's names because that's the way it works. They're not going to tell us. Okay. So if you file one of these, whether public corruption complaint or the criminal complaint, don't expect them to call you up and tell you about it. Expect just the opposite. And I know it's totally opposite from what we would think, which is wanting to call them. What's going on? What's going on? I filed a criminal complaint yesterday. What's going on? Well, I filed a criminal complaint 2 weeks ago. What's going on? How do you know they weren't already arrested? Just saying. But keep that in mind. When you file these things, they're not going to tell you about it. Okay? Just not how it works. So, much love, everybody, and thank you for the likes, the follows, the shares, and hopefully we stay going here on YouTube and Facebook, but we'll see. Otherwise, the only real support I can deal with right now, being as they've killed my PayPal and Cash App for some reason. If you'd like to help support, you can send it over to the office at 6477 West Fairview Avenue, Suite C, Boise, Idaho, 83704. New postal money orders, regular money orders, cashier's checks, cash wrapped aluminum foil, anything like that, gold, silver, coinage, whole 9 yards. And any books you think I might want to have and read. My collection just grew again. Thank you, Rob, out there. He got some Idaho court reports books volume set. There's a couple volumes missing, but there's lots of good information in there. So want to thank my team and all the supporters behind the scenes here and over there and over there. And of course, give thanks to God for everything He's providing for us here. So we will prevail. I can guarantee you. Well, I guess I shouldn't say I can guarantee you, but I have faith in God that we are going to prevail. So I hope that you folks out there pick up a pen and start putting pen to paper and filing this paperwork, whether it's in your own personal case, whether it's a criminal complaint, what have you. But let's start doing something. Let's get her done. This is our republic if we can keep it. It's up to us. Okay. So another thing too is, for those of you on Facebook or YouTube, see if you can find some people in your area, at least your state, at the minimum, your state, and start working together. Even if you have private Zoom meetings, phone calls, make some connections here, folks. Where are you from? Start putting it out where you're from, what state you're from, and see if you can find other people to work with that are right here. and start working together because we have strength in numbers, right? Multitude of counsel, strength in numbers. That's what we need to do. I know it's hard to stand up by yourself. I've, I've actually done it. And I've had to stand up by myself, but I can tell you it's a lot easier and a lot better when you have people in support and can back you up, especially as witnesses. Two or more to the same overt act. So at a bare minimum, two witnesses with you. Okay. So much love, everybody. And thank you for the prayers and continued prayers. I greatly appreciate it. Let's pray for those children that are being rescued, and let's pray for our enemies. Hopefully that they have a change of heart. Right? It's never too late to have a change of heart and turn to God. So, all right. Hope everybody has a good week, and those on Patreon, we'll see you Wednesday night. And it's already I've already sent out, unless you're new, and I'll send out a private message to you with the information to the Zoom meeting. But everybody else has already received the weekly Zoom meeting. Unless that changes, I'll send that out. But I'll make a post on there to reiterate that the previous Zoom information that I have sent out is the same every Wednesday. Unless that needs to change, then I'll change it. But just so you know, if you're on Patreon, on my Patreon, which is patreon.com/Kirk's Law Corner, and you have received that information on the Zoom meeting for Wednesday night workshop, it's the same, hasn't changed. So look forward to seeing my patrons over there on Wednesday night workshop. And have a wonderful night. Love everybody. And thank you all for being here, wanting to learn, wanting to be active. Greatly appreciate you. All right. Much love. Good night, everybody.